Texas voters have approved Proposition 15, a constitutional amendment that formally adds parental rights, including decisions about a child's care, custody, and upbringing, into this state constitution. Supporters say it strengthens families and clarifies long-standing protections, while critics worry it could interfere with public schools or limit the state's ability to step in when a child needs help. To help us understand what this amendment actually does, what it doesn't do, and what changes Texas parents might see now that it is in effect. We're joined by Nour Acosta, Senior Legal Clinic Supervisor at the University of Houston Law Center. Nour, welcome to Hello Houston.
Hi, thank you for having me.
So Nour, at first glance, Proposition 15, it sounds pretty straightforward, pretty obvious. Parents have a fundamental right to direct the upbringing, education, and care of their child. I mean, to me, I think, who wouldn't want parents to be involved in their child's life unless a child is unsafe? So how does Proposition 15 balance parental rights with child protection?
That's a very good question, Celeste, because it's very vague. And that's what critics are saying, is that the new amendment doesn't define the terms care, custody, and control, or what making decisions for a child's upbringing means exactly. So the critics argue that they're concerned that this is going to sway and shift the balance of parental wishes over possibly the health, safety, and welfare best interest of the children.
Right.
Well, Nour, I always grew up with your parents had the last word. I mean, it was like, I'm going to call your mother. So where did this go off track, where parents don't have parental rights? What's going on that even prompted this to come about?
Well, parents do have parental rights, and it's been a fundamental liberty interest that has been in case law precedent, Supreme Court, and in the 14th Amendment of the U.S. Constitution. All say that parents have the fundamental right to care, custody, and control, and to make decisions regarding a child's upbringing.
So why do we need this? Is this just MAGA grandstanding, saying, hey, we're going to put it in the Constitution because we are just going to do it?
Well, supporters are saying that the reason they wanted this amendment was so that it can be enshrined in the Constitution, make it difficult to change later. Although it is case law precedent, they don't want courts in the future to erode this precedent or state law to change. I mean, it's also actually in the Texas Family Code right now that says specifically parents have the duty and right to moral and religious training of the child, as well as that states agencies cannot interfere with that right by issuing policies or rules that violate that fundamental right.
So Nour, when you say it like that, it seems very high level. It sounds very legal. So when we look at the words like upbringing, so what happens if a religion or a parent says, I don't believe in modern medicine, so if my child is sick, I'm not going to necessarily take them to the hospital. Or I believe in my household that withholding food for days on end is a part of punishment, and that is within my household belief and upbringing. What type of legal action can be taken if the parent then argues, in Proposition 15, in our state law and our code, that is my parental right?
Well, you'll probably see a wave of lawsuits against school officials for this reason. And like I mentioned, it's vague that these terms are not defined. And so the term control is going to have to be interpreted by these courts to weigh the balance of parent wishes against legislative interests such as child welfare and health and safety regulations and school curriculum requirements as well.
Yeah. You talk about it being vague, but it's not unthought out is my approach. And here's the cynic in me, that this was a very vaguely written bill or proposition, however you want to say it, because it's hard to say, oh no, parents don't have the right to take care of their children. But that's what it says on the surface. And as Celeste has brought up and Frank has brought up, that really there's something else at play here underneath it, that it allows for censorship of books by school districts. It allows, because you can use the argument, well, not all parents would agree to have this here. So it's taking all of the control away from organizations and institutions we have over time allowed to do a lot of this work, and for the most part has done it very fair and just, that there's something else at play here. Am I off the rails believing that, or what does it say legally?
Well, textually speaking, the language is very similar to that of case law precedent. So nothing has really changed textually speaking as far as the language of what our legal fundamental right as parents is. However, this just gives people who do disagree with how schools, what school curriculum includes and possibly topics of LGBTQ, for instance, or gender identity issues, it gives them another leg to stand on when filing lawsuits and can now bring those in state court as well as the federal courts. Although, like I mentioned, it was already in the Texas Family Code to some extent. I think it's a double-edged sword because I think you could also see parents on the other side who do want those topics in their schools and in their curriculum because they are part of LGBTQ, for instance, community families, and they want that as part of their children's upbringing. So like I mentioned, it's really going to be up to the courts and judges to decide what that interpretation is and how to balance that control of what parents want and their fundamental right versus the legislative interests of child welfare and school curriculum requirements and health and safety. And I think you're going to see various rulings across Texas, possibly differing depending on which area you're in.
But couldn't it have been written clearer so that you don't have all of this speculation that follows? Or is that the way we do all of these propositions, and this one's just getting the attention right now? I don't understand why you would give something to people to vote on, which we really don't understand what it means until then courts look at it. Shouldn't that be part of what we do when we propose these things?
And that's what critics are saying, is that while this amendment affirms the fundamental rights that parents have concerning the upbringing of their children, it does not affirm child welfare laws. It doesn't affirm other best interests of the children issues, but those are still there. It doesn't take that away, it doesn't take those laws away either, is what they say on the other side. But you're right, they could have defined what does control mean, but they didn't. And I have that same question.
Well, I love this double-edged sword you brought up, because what if you're, as a parent, you say, I want my child who's gay to have LGBTQ support at school. And as a parent, I'm demanding that of the school. And the school says, well, we can't do that because we can't have anything DEI in our school. Well, then I'm going to sue you because you are overstepping what I want for my child. Is that a legitimate argument?
Yes, it could be an argument. And these are arguments that are already being raised even prior to Prop 15 passing. I don't know if you guys have heard about the parents from Bel Air High School who are suing school officials, and that's under federal laws that they're suing, but they similarly could now bring it under Prop 15. And that's for those who out there who don't know what we're talking about. It's parents have sued schools for referring to their daughter by masculine name and male pronouns when they've asked that they use the female pronouns in the name that they gave her, and they continue to do otherwise. So that's still in court and being litigated. So I'm curious to see what the court says about that.
Nour, are there other states that have these type of propositions, and what can you tell us about that? I understand Texas is not the first state to implement a parental rights type clause.
I can't tell you. I would have to look into that further to see what the states have been doing with that type of clause and if it's changed recently. But I just know that in Texas, you're definitely seeing this being brought up more. So they will probably look at other states and seeing how they're handling it. So it's something to definitely keep an eye out for.
Which then the question then I think becomes is, do you think that the state can balance the pendulum swinging too much to enforcing parental rights, but yet still making sure that children are protected if they are in unsafe environments?
Well, I think it depends on what you mean by unsafe. If people have different views of what is considered abuse or neglect.
Right.
And so it's really going to be up to the judges to decide what they consider being outside of that or within that. So if they think that, referring to a child by a name that they don't want to be referred to is a form of abuse or neglect, then that's something they're going to have to decide on.
So then what would this do to DCFS, Department of Children and Family Services? Does this strip all their power away?
No, it does not. I mean,
How then do both exist?
Well, critics say that it could inadvertently hinder state agencies and social services from doing their job to protect child abuse and neglect from happening or going on. But the reality is those laws are still there. And so it's up to judges to balance that out with this amendment, which is actually just a codification of what's already been out there, and that parents have this fundamental right to make decisions. So they really are going to have to define, what does control mean, and in what cases is control in the ballpark of the parents to make a decision concerning upbringing, and what cases is that control for legislative interest, serve a purpose for legislative interest.
Yeah, but to what Celeste was saying earlier too, if a parent decides that I punish my child when they're wrong by not feeding them, and that is my parental right to do that, it seems as though this new law, supports that because it's giving the parent control in how they want to bring up their child. And a state agency, DCFS or whoever who would intercede in that, has no right to do that because of this law.
Right.
And you're right that could inadvertently happen, is that...
Not inadvertently, though. It sounds like it's written in that way specifically. Now, I know it hasn't been litigated in courts and such yet, and I understand how that redefines laws, but it just seems like it shouldn't have gotten to this point that a proposition written this way could be put on a ballot that could, in effect, negate care and protection of children by the state, which is often there to give care and protection to children who don't get it.
But I don't know if I fully agree with that, because
Yes,
it's already been written that way. It's
Okay.
been written that way in case law. It's been written that way in the Texas Family Code, and it's been stated that way by Supreme Court in more than one case. So essentially, it's the same law that's been out there. It's just codified now and enshrined in the Texas Constitution so that it can't be changed going forward. But yes, critics are saying also that it could be, because it's giving people another leg to stand on for parental rights, then it could possibly inadvertently.
Okay, I'm going to cool
Nor
down
we-
now. That was my hot
I
moment.
have a question. We have a tendency to focus on schools, but does this also apply to, say, health clinics? And a child wants to go to a health clinic, a 17-year-old, 16-year-old, and ask for condoms. And that clinic now has to say, only if you get a note from your mom can we give you a condom. Is that true?
Yes, this can apply to health needs as well, medical needs, as well as schools, as well as social issues. Yes, it's not just limited to schools and education.
Yeah. So it could be, I know abortion is outlawed, but it could really go to teenagers who have issues that they don't want to discuss with their parents. And now health clinics and schools and counselors may not be in a position to discuss it with them either, because without parental permission, and they don't want to go get parental permission because they don't want mom and dad to know they're pregnant. Right? And so they go to the school counselor, and the school counselor says, I can't talk to you about this without permission from your parents. It's just, it's a real dog-eat-dog situation.
Yes, it would be helpful if we got more direction from the legislature.
You're absolutely right.
Yeah, and it seems like that's the problem essentially, is if in our state law it becomes code or it's codified and it becomes harder to then turn over, that's where the danger starts to happen, because if you do see an uptick in parents or children that are unsafe, the protection of a child is less, but yet the enforcement over parental rights the pendulum has swung to that level. That, I think, is not the best way for our state to be legislating. Mm-hmm. That's just my thought. Those are my 2
parents
cents.
should have rights.
And as a parent, teenagers, I don't have one yet. My son is 5 today, but I would imagine that there are social things that you do want your child to come talk to you about. However, not all parents are going to be loving and accepting and open to hearing their child, what they say.
And what if the kid has a drug problem and goes to this counselor and says, I think I have a drug problem, but I don't want to tell my parents.
Yeah.
And the counselor now has to say what? Well, you have to tell your parents before I can help you. Mm-hmm. I mean, there's so many worms in this can. I don't know how we're going to get around it. I'm worried.
Yeah, I'm curious to see in that Bel Air case too if they are going to say that they should have given the parents all those records, because that's one of the issues there is that the parents have requested all the school records and the counseling records where the talk about gender identity has been an issue and they had not received it.
Interesting.
Nour Acosta is a senior legal clinic supervisor at the University of Houston's Law Center. Nour, thank you so much for joining us today on Hello Houston.
Thank you for having me.